Hi, this is Chris Malloy from Live Music New England. We're here today with Gary Lambert, who's a patent attorney with offices in Nashua and Boston. Gary recently retired after a 30-year career in the Marine Corps Reserves and was recently elected to a state senator position representing Nashua. So thanks for being here today,
Well,
Gary.
Chris, thanks so much for having me. It's really a pleasure, and I know we've worked together in the past, so thank you for this opportunity.
Yeah, it's good to see you. I could talk to you all day about state politics, but today, for this interview, we're going to talk about your expertise in copyright and patent law, specifically regarding musicians and the music industry. You're a registered patent attorney. What does that mean?
What that means is I am registered to practice before the Patent and Trademark Office on patent matters, and what it technically means is I have a separate license. So I'm a regular lawyer. I'm admitted to the New Hampshire bar and the Massachusetts bar, but I'm also admitted to the bar at the Patent and Trademark Office. And to be able to sit for that bar exam, you have to have a degree in engineering or science. So that limits a lot of attorneys, because a lot of attorneys major in other things other than engineering and science.
Sure. So
most patent attorneys are kind of, I wouldn't say a misfit, but we started off wanting to probably do something else.
Okay.
In my case, a biologist, and then I moved into the law. But I have a chemistry and biology degree, which allows me to sit for that exam, and then I passed the exam.
Okay. Now, you've represented some major corporations such as Walmart.
Mm-hmm.
Are there legal similarities between, say, a solo musician from Nashua and a company like Walmart?
Absolutely. You know why? Because the law is the law. And so even though I represented Walmart on a patent infringement case in Miami for a case that lasted beyond 5 years, the law is the same for the individual inventor or musician or copyright owner or trademark owner as it is for Walmart.
Now, if a local musician or any musician writes a song, what do they have to do to own the rights to that song?
That's a good question, because there's a lot of misinformation out there. The beautiful thing is, essentially, to get rights and copyright, they need to do nothing. Upon publication of any type of music, whether it's the written word, whether it's a video recording, whether it's a book, whether it's a painting, whatever, those are copyrightable matters. Immediately on publication, you have rights and copyright. However, there's where your rights end. You won't be able to enforce those copyright rights unless you file a copyright registry.
Okay. And what is the difference between copyright and trademark?
Very good question as well. First of all, two different offices. Library of Congress runs the copyright matters. U.S. Patent and Trademark Office runs trademark. Copyright only pertains to matters of authorship, such as writing a book, writing a music script, making a song. Now, trademarks apply to trademarks only. And now, a band may have a trademark name. The Beatles, for example, is a trademarkable name, but that's got nothing to do with the copyright issues.
Okay. When planning to record an album, what steps should a band take to cover themselves from a copyright standpoint, and maybe even in a broader aspect, a legal standpoint?
The first thing they should do is take whatever musical score they've got, or videotaping of the song, and file an application for copyright registration. And the reason for that is this. Yes, they have immediate rights in copyright upon creation of the work. And that's what a thing is called in copyright, the work.
Okay.
So they have immediate rights in that. However, they can't sue unless they get a registration. So, and not only that is, if the infringing activities take place before the application is filed, they are limited to actual damages. Actual damages being this: they will have to prove how much they lost as a profit as a result of that copyright infringing activity. Now, if they file and then the infringing activities take place, then they are entitled to attorney's fees, which is always a big deal. I mean, everybody wants to have their attorney's fees covered. And secondly, they're entitled to statutory damages of $750 to $30,000 per infringing act.
So when let's just say that the band gets together, they record their song, and they say, we're almost there. We're not in the studio yet, but we get together and we record the song pretty much as it's going to appear on the album, but it's not on the album. Does that cover that particular song that will be on the album, or is that a separate registration?
Well, it's always important. I mean, there's always going to be improvements and modifications and that type of thing, but it's good to get something on the record. The filing fee for a copyright application is $45. So if you have to file 2, 3, or 4, once you get to the final thing, that's okay. Of course, yeah, money's always an object, and you may want to wait, but it's good to get something filed right away.
For the $45, you might look back and say, that was the stupidest money we didn't spend if you're not protected.
That's right.
What about from a broader standpoint? Is a band potentially exposed when they're creating an album, whether it's a name or the name of songs or the type of songs?
Well, let's take up the name first, because now names get into trademark, not copyright. And the thing is, if they were to just create a name and go out there and start marketing them themselves, they could actually be infringing on another trademark. So it's always important to do, or have, preferably, have a trademark attorney look into that and do a search, and here's why. Trademarks are not like domain names, where you go on to, say, GoDaddy.com, punch in the name, it comes up free, and then you take it for $10, okay? Trademarks involve a thing called the likelihood of confusion. And so that test is much more complicated. It involves many factors. Do the names sound the same? Do they look the same? Is there a band involved in the other infringing mark, or is it a restaurant? Or is it a veterinarian's office? Okay, so the farther it is away from the band environment, the less likely there is to be a likelihood of confusion, even if the name might be the same.